Ladies and gentlemen, before we start the meeting tonight, if you have a speaker's request form, if you plan to speak this evening, if you could make sure you fill out that form and submit it to Tom over here. And also, many people earlier tonight had just marked the general public comment. If you could write on there, if you're just doing a general comment, that's perfectly fine. You filled it out perfectly. If you want to speak on the seismic retrofitting item, that item is 11, so XI. And that would be under the agenda item number. So if you want to correct that or just let us know before when I start calling out names, that'd be great.
Where's Yvonne?
Welcome to the Rent Stabilization Commission meeting for Thursday, June 14th. Commissioner Bergstein, or Vice Chair Bergstein, would you like to lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Amen.
Thank you. Mr. Secretary, could we have a roll call?
Commissioner Maggio? Commissioner Gregoire?
Here.
Commissioner Topchian?
Here.
Commissioner Charity?
Here.
Vice Chair Bergstein?
Present.
And Chair Kerpes?
Present. And it looks like we have an oath of office to be given.
Good evening, commissioners, staff, and guests. I'm Yvonne Corker, City Clerk for the City of West Hollywood, and I have the pleasure of administering the oath of office to your newly appointed Rent Stabilization Commissioner, Karen O'Keefe. So Karen, raise your right hand and repeat after me. I, Karen O'Keefe, do solemnly swear that while serving as a member of the Rent Stabilization Commission of the City of West Hollywood, that I will support and defend the Constitution of the United States and the Constitution of the State of California, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties upon which I am about to enter. Congratulations.
Congratulations. Our newest member, Commissioner O'Keefe. And since I kind of went out of order on the agenda, I guess, can we let the record show that for our roll call that Commissioner O'Keefe is present?
Yes.
Thank you. Have all the commissioners had a chance to review tonight's agenda?
Yes. I move approval. Second?
Motion and a second. All those in favor say aye.
Aye.
Any opposed? Motion carries. And have you all had a chance to review the minutes from our May 10th meeting?
Move to approve as submitted.
Do we have a second?
Second?
All those in favor say aye.
Aye.
Any opposed?
Should I abstain since I was not a commissioner?
You can
So I
abstain. Yeah. So we have one abstention. All right, moving on to public comments. So this time, the Rent Stabilization Commission cannot, so this time is set aside for public comments. We cannot take action on these public comments, but we ask that they remain within the purview of the Rent Stabilization Commission. We will start with Eric Larson. Could you please come to the podium? Unless this item is regarding the seismic retrofitting item, just let me know and we can put you in the right order at that time. I had him put on there that it was for retrofitting. Okay, then we'll go ahead and have you wait a little bit until we get to that item. Thank you. The other public comment I have that's not related to public or to the retrofit item is Stephanie Harker, former commissioner. If you could state your name for the record, and you have 3 minutes.
Good evening, commissioners and members of the public. Stephanie Harker, City of West Hollywood. Congratulations, Ms. O'Keefe, Commissioner O'Keefe. Glad to see that you managed to infiltrate the boys' club. Gail Sains and I kept it going for a while, but welcome to the commission, and welcome for this on behalf of the members of the community. I just wanted to say again how much I appreciate all of your hard work, the staff's hard work. There are, as we all know, more renters than owners in the city of West Hollywood, and on various occasions, the city has really come to my to help me a lot with issues that I was having, and my neighbors, and they always come to me and say, what do I do? I say, you call the city and you talk to the rent stabilization department. So thank you again for all of your work, and not making comment one way or the other on seismic retrofitting, but I'm certainly happy to hear that it's been going forward and that the word has been getting out and that the public has been involved and included. Thank you.
Thank you. All right. Mr. Secretary, we don't have any other public comments at this time, right? The other
For
comments?
this item, I don't believe.
All right. Then we will move into the staff director, or I'm sorry, the director's manager's report.
Thank you. Good evening. Looking at our look-ahead calendar, our next meeting would be on June 28th. That meeting has 2 appeals scheduled on it. And the next meeting is July 12th. There are 2 appeals scheduled that evening. We are looking to reschedule those appeals to the July 26th meeting. The July 12th meeting will have the seismic retrofit cost share discussion on it that has been mailed out to all landlords and tenants. And so that evening will be have that item on it alone at this point. We have the study session scheduled now for the July 26th meeting, and I'd recommend that we just move that study session to the meeting in August so that we can have the appeals on July 26th. Separate from the Rent Stabilization Commission meetings, after this meeting on Saturday, we will be holding a 3rd community meeting on cost sharing for landlords and tenants in rent-stabilized properties. That will be here at the West Hollywood Park Auditorium from 11 a.m. until 2. The intent of that meeting is to provide any outcomes and continued discussion of this evening's Rent Stabilization Commission item when you get to the discussion piece, which is on cost sharing for seismic retrofitting. This concludes my report.
Do we have
Two
any questions?
I'm sorry, I thought this Saturday's meeting was at Plummer Park, rooms 5 and 6?
That had to be corrected. We did have the meeting scheduled on the 23rd. However, that was corrected some time ago. The meeting and location that did go out to the community that is on the website and on the calendars is this Saturday, the 16th, at the auditorium here at West Hollywood Park.
I need to correct my calendar, thank you. And then can I ask for the June 28th meeting dealing with the AGA, can we have our TV people put the link for the Los Angeles County CPI on that screen? I know that we sent it out to landlords and tenants on one of our mailings, but since we'll be discussing that evening, if we could have that on the screen. And secondly, as part of that discussion, I know that you were part of a group, I think from Beverly Hills, from Los Angeles, Santa Monica, talking about rent stabilization. I think it was West Side Realtors. If you could briefly touch on the increases in Santa Monica and in Los Angeles and ours, and what formula they use, if it can be a brief part of your discussion.
And that's for that evening?
If possible.
You bet.
If you think it needs to be more in-depth, I want to agendize that for a future meeting, but I just thought it'd be timely for that June 28th meeting. Thank you.
Are there any other questions? All right, seeing none, we'll move on to commissioner comments. Thank you.
I wanted to comment that I again attended the New Renter Alliance meeting at Plummer Park. The chair was there as well, and I want to again encourage them and congratulate them for all their efforts and energy they are putting into important conversations that affect rent stabilization and rent control departments in general. Thank you.
Are there any other comments?
I'll just comment. I'm so pleased to see so many people in the audience here tonight. In all of my years on the Rent Stabilization Commission, I have never seen this many people show up for a meeting. So that's terrific. Thank you all. Thank you all for coming. Unlike the Planning Commission and the City Council, I think people stay home and watch Rent Stabilization on TV. So we appreciate everyone coming out and being part of your city government.
Any other comments?
Just a quick one. I attended both cost-sharing community meetings here in West Hollywood Park Auditorium and also the Plummer Park, and I think it was well attended, well organized, very informative, and there were a lot of great ideas that the community shared with staff and with others, and it was really exciting to be a part of it and to observe and to see how the community is very active and the community cares about what's happening, and it's very important as an evidence we have this wonderful group of people here. Thank you.
Thank you. And I just want to, do you have a comment? Another comment?
Just wanted to first welcome our newest commissioner. I really think that this commission is second only to planning in the impact that we have on the residents, City of West Hollywood. So welcome. I think it's an exciting commission to serve on, and if you're a friend of Lindsay's, I know that learning curve will be short. Former Commissioner Harker, you not only upheld the breaking of the boys barrier up here, but you were a solid, effective commissioner. You were not just a female member of this commission. And I do miss, we used to carpool together. We never violated Brown Act and discussed agenda items, but we had very spirited discussions, both coming in and going out, and I do miss that and enjoy our friendship. So thank you for your prior service, and welcome to the commission.
Yes, I also want to welcome you to the commission. We look forward to working with you. We know you'll do a wonderful job and a great addition to the commission.
Thank you very much. I look forward to serving, and I'm happy to be here.
All right, any other comments? All right, then we will move on to our first items on the agenda tonight, which is our our commission appeals. The first one will be Appeal D4295, at 1135 and a half North Vista Street, rent reduction appeals. Do we have both the tenant and the landlord present? Either the tenant or the what's your name, sir? 10. All right. What's the? Oh, did I say the wrong? I must have said the wrong address. Like, sorry about that. 1137 and a half North Vista. Okay. And do we have the property owner, Mr. Katz? No? Okay. Then what we'll do is we'll go ahead and you'll have 5 minutes, or actually we're going to hear a staff report first, and then we'll ask you to come up and we'll give you 5 minutes to present your comments. All right?
Good evening, Chair, Commissioners, Jonathan Holub, Staff Attorney, and Counsel for the Commission tonight. In this case, the tenant was awarded a rent reduction of $11 for the removal of a hedge and a $28 reduction for the failure to paint the bungalow exterior. The landlord has appealed both of these issues. Staff recommends that the Commission affirm in part and reverse in part the hearing examiner's decision. There's no dispute that the exterior paint has not been painted in over 7 years. The hearing examiner found that the landlord did not present sufficient evidence to show that painting was unnecessary, and staff recommends that this part of the decision be upheld. With respect to the reduction for the hedge, the tenant claimed that the landscaping housing service had been reduced because there was no longer a lawn and the hedge was taken out. But the evidence shows that this landscaping was replaced by other, more drought-tolerant landscaping. The photos show that there are cacti and other plants where the lawn and hedge used to be. Thus, the evidence does not support a finding that the housing service has been substantially reduced. Nothing in the ordinance states that a tenant is entitled to a particular type of landscaping. Therefore, staff recommends that the Commission reverse this part of the decision. I'm available for any questions.
All right, thank you. Do we have any questions for Mr. Holub? No? All right. Again, I want to ask, is the property owner present, Mr. Raphael Katz? No? Or a representative? No? Okay, seeing none, then we will go to Mr. Asad? Sorry, from Asad. If you could come up to the podium, you'll have 5 minutes. We just ask that you not present any new evidence, state your name for the record, and you can begin.
Hello, thank you very much. My name is Ramzi Asaid. I live at 1137 and a half North Vista. I've lived in West Hollywood for quite a while now. Thank you very much for your time. I appreciate it. I didn't expect to be here, but here we are. In regards to the recommendations, thank you for putting through and affirming the first recommendation. As of now, they have not fulfilled or rectified that situation. And I'm aware that I can't present anything new, but I'm curious to know how that ultimately is rectified, if that is an ongoing situation. Secondly, in regards to the second recommendation on the part of the staff, that was to reverse the original recommendation on the part of the City of West Hollywood. It's true, there has been a replacement. It's not as though other landscaping has not been put in place, but I do believe the cost of that landscaping has been greatly reduced, and I believe that if possible, that benefit should not just benefit the landlord, but also the tenants as well, in cases where we are effectively paying for that same service but getting less. And that's just my position. Again, thank you very much for your time, and that's all I have.
Thank you. Do we have any questions for Mr. Asad? All right. Thank you. Go ahead and have a seat, and we'll begin our deliberations if we don't have any other questions this time. All right. Would anyone like to begin?
I'd be inclined to agree with the staff's recommendation on this matter. I do see that the drought-tolerant plants are sufficient replacement for what were, heavily water-consuming plants. As a matter of public policy in Southern California and in the Southwest in general, we've all had to do our part to reduce water consumption. And I'm not here to knock the landlord and the landowner for, replacing those plants with drought-tolerant plants that seem to me to cover the space of old plants.
Thank you.
Thank you, Chair. I reviewed obviously the evidence submitted, and I don't believe that the replaced landscaping constitutes a reduction in services, and I believe there is a substantial compliance under the RSO. Therefore, I believe that the examiner erred in the when awarded the $11 rent decrease. So that's why I am in agreement with staff recommendation to reverse that part. And I do agree with affirming the part in regards to the exterior paint. It is also supported by the record evidence, and it is in compliance with the ordinance. So I'm going to support the staff recommendation.
Thank you. Vice Chair. Oh, if you could turn your microphone on, there's a little button at the very base. There's a.
All right.
There we go.
I agree with other two commissioners and with the staff recommendation to reverse in part and affirm in part the hearing examiner's decision to have the reduction for the exterior paint, but not for replacing the hedge with drought-tolerant landscaping.
Thank you.
Yeah, and I don't have anything, I agree with everything my fellow commissioners have said in the recommendation of staff, so I would support a motion with respect to the recommendation of staff in this matter.
Okay. Commissioner Maggio?
I concur. Let me see, I'm not. There you go. Yes, a exterior is required to be painted every 7 years. There's no dispute there. And unfortunately, we can't have as many beautiful lawns as we once did, and we have to do our part in conserving water. And so these drought-resistant plants are certainly apropos, and so therefore I will agree with the staff report.
Thank you. Vice Chair
I would be inclined to agree with staff's recommendation. There is nothing in the record that shows that the removal of the hedges, substantially decreased the habitability of the apartment. It's nothing about it was in a east-west facing window and now the sun is beating in, or a lack of privacy from an adjoining unit. So it's just really an upgrade on the landscaping to drought tolerance. So I would agree with staff on this. And as far as the exterior painting, the rent reduction will remain in place till the landlord repaints the building, and at that point they can move for a restoration. So I would also be in favor of staff recommendation.
I would agree with my fellow colleagues. I think that it's pretty clear on the external paint that that needs to be replaced, and we should uphold the hearing examiner's decision on that. I also agree with staff's recommendation that the hearing examiner erred in her analysis that in awarding the reduction for the removal of the hedges. In many cases, when the commission has weighed in on landscaping issues, the tenant has provided information such as shade from the trees or some sort of utilization of the area that was in question. And in this case, it doesn't seem to be that there was evidence, substantial evidence to support that claim. So I would agree with my commissioners that and the staff recommendation, and would ask for someone to make a motion.
I'll make that motion. Resolution RSC 18-522, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming in part and reversing in part the hearing examiner's decision on D-4295, 1137 1/2 North Vista.
Do we have a second?
Second.
Vice Chair Bergstein motions, Commissioner Maggio seconds. Do we have any more discussion? No. No more discussion, then we'll go to a roll call vote.
Commissioner Maggio?
Aye.
Commissioner Gregoire?
Aye.
Commissioner O'Keefe? Commissioner Topchian?
Aye.
Commissioner Charity?
Aye.
Vice Chair Bergstein?
Aye.
Chair Kurpies?
Aye. Thank you very much for attending this evening. If you have any questions, you can contact City Hall. And we will move on to the second appeal for this evening, which is item D4252 CD regarding 836 North Westbourne Drive, number 208, also rent reduction appeal. Do we have both the tenant and a landlord representative? Sir, what's your name? Rod Cradigal, I'm the tenant. Okay, and Elliot Barstel? Washtel, okay, thank you. So we will first start with a staff report, and then we will ask the appellant to, in this case, I believe it's the landlord. No, Mr. Crateville. We'll ask you to come up to speak. You'll be able to divide your time. You'll have 5 minutes total. You'll be able to decide how you'd like to split your time so that you can leave some time for rebuttal. But we'll start with our staff report.
The hearing examiner awarded the tenant a rent decrease of $15 until the landlord could provide substantially the same amount of heat in the bedroom as was provided by the furnace that has been removed, and take all actions reasonably necessary to perform this maintenance. The furnace that was removed was replaced by a new, more efficient furnace, but the vent from the heater that led into the bedroom was sealed off by order of the city. On the tenant's application for a rent decrease, the hearing examiner agreed that there had been a substantial reduction of a housing service since there was no longer a vent that opened into the bedroom. In response to the rent reduction, the landlord installed an electric heater in the tenant's bedroom. The landlord then applied for a compliance determination to have the rent reduction restored. The tenant objected to the placement of the heater and worried that it could be a fire hazard. Staff recommends that the commission affirm the hearing examiner's decision to restore the rent. The tenant failed to produce any evidence that the new electric heater creates any kind of safety hazard. His stated concerns about his dog, raised for the first time on appeal, constitute new evidence that the commission cannot consider. In any event, there is no objective evidence that a floorboard heater is generally unsafe. I'm available for any questions.
Chair,
Yes.
can I?
Yes.
Yeah.
Would you like to ask a question? Okay.
Sorry, it was too loud. I don't know what's going on with the
Hold me up.
microphone. I scared everyone. I'm sorry. Thank you. Question about the concerns about the safety of the dog. I think it was discussed at the hearing, because on page 53 there is mentioning about that the tenant is concerned about his dog pushing the door, etc. So I want to know if to what extent there was the discussion about the dog.
There wasn't any.
Actually, I apologize. You know, I listened to the transcript today, and that is correct. It was mentioned one time. It was mentioned. I don't know if there was a big discussion, but the tenant did, in fact, bring it up, I believe, during the hearing. So that is not correct. And so it was an issue that was raised in the underlying hearing.
So anything that would be mentioned today in the tenant's comment, we have to disregard about the dog?
No,
or we
it was raised in the hearing, so you can consider it. It's not new evidence, but it's not a, you know, the evidence doesn't necessarily doesn't change the staff's recommendation. Because the statement in the staff report that there's no objective evidence that the floorboard heater is generally unsafe, that is correct. But like I said, the statement that it wasn't brought up at all is not correct. It was brought up once, briefly.
If I can interject, I think what did you author may I ask if you authored the staff report or not? Because I think what the staff report is telling us is that in the context of the dog pushing the door open and creating a fire, that was brought up during the hearing, but the context of the dog being injured itself, I think, by the baseboard heater was not an issue. That's how I understood it.
Okay, then that was the limit of the discussion. Yes, yes. So it has to be narrow. He can't bring up new evidence about the safety of the dog, but there was a discussion about the door opening and the dog possibly opening. So there was a statement about the dog, but it didn't get into the effect that it has on the dog.
Okay.
Just whether the door would be pushed by the dog.
Do you have any other questions?
I would just say we could let the tenant to, say whatever.
Do you have any other questions for
No other
staff?
question.
Okay. You had a question.
Jonathan, could we have more of an explanation on the vent itself? If it was once allowed and in working order, and then the unit is safer presently, why can't that vent be used again?
I don't know the rationale for why code compliance asked the vent to be removed, but it's not particularly relevant to the determination that we're making here today, or that you're making here today. The decision is whether or not, the determination is based on whether or not there was an error in the underlying hearing, and the reasons behind the removal are not relevant to this determination, and I don't know what they are. But code compliance apparently told the property owner that he needed to remove that vent.
Would it be under one of our own regulations, which I don't seem to see it here?
If code compliance asked them to remove it, then presumably it was based on an assessment that they made, and the landlord didn't challenge that apparently. So
Usually there's a reference in terms of a rent regulation, and I didn't see that. It's not in the ordinance, I know that, but it would have to be then in the regulation.
it wouldn't be an RSO provision.
All right,
If that's the question, it wouldn't be an RSO provision. It would be some other part of the code that code compliance enforces.
All right, thank you.
Keith, did you have any questions? Your microphone.
Turns off. So if the dog were injured subsequent to the decision before the appeal, I understand that in some cases new evidence can be introduced if it couldn't be discovered with due diligence. If that had happened, and I wasn't clear on the timing, so if that had happened later, could that either be introduced here, or would we be able to remand it if that was something worthy of consideration?
Well, as was discussed previously, the issue of an injury to the dog wasn't actually raised, so it wouldn't be something that you would consider now at this time.
Okay.
If there's some other issue that the tenant needs to have addressed, I believe the hearing examiner mentioned in her decision that the tenant can file for a new rent reduction, and an entirely new case could be brought. But that's not what you're here to consider tonight. It's just whether or not the landlord complied with the order, and from what staff can tell, the hearing examiner was correct.
Thank you.
Any other questions? Yes.
So I wanted to make sure that I'm clear that this issue stems from there was some type of a faulty furnace in place in the apartment. The landlord pulled permits, installed a new one. The city code compliance required that the vent facing or going into the bedroom be removed, and the landlord subsequently installed the baseboards. Correct so far?
That's my understanding of the.
So what I don't see in the record is any mention of code compliance coming back out pertaining to the installation of the baseboards. Am I correct? There's nothing in the record that
I'm not
reflects that?
aware of them coming back out to look at it.
Thank you.
Are there any other questions by commissioners?
It's just more like, I don't know whether it's a question or a clarification. In the recommendation, it states that the tenant failed to produce any evidence that the new electric heaters creates kind of a hazard, safety hazard. So if we hypothetically speak, what type of evidence would satisfy the purpose of the hearing? I guess kind of putting the burden on the tenant, saying that you have to prove to me that the heater is a safety hazard. So what type of proof that the tenant could have submitted?
I'd rather not hypothesize. It just wasn't presented in this case, because that would be a very fact-specific determination. but it just wasn't presented here, and I don't want to
Speculate, I
engage in
understand.
conjecture about what might happen in a different case.
And the examiner never really clarified, did not ask specific questions in that regard, if you recall.
My recollection is that the issue was raised, and that the tenant did not present anything other than a subjective sense that he didn't think it was safe. But there's no evidence
Okay.
to indicate that it's not safe.
So anything said today here in that regard would be considered new evidence then, if nothing was presented at the time?
If it's completely new, then you can't consider it. So if it's new information about safety, then that's not something that you can consider, generally speaking.
Thank you, legal counsel.
Any other questions? I just had one question about if some of the issues brought up in this had to do with, as you mentioned, that the hearing examiner said you could refile. There's no time limit for refiling on a separate issue for a rent reduction, right? Let's say if he were able to, I think his argument in here was that the price differences in the bill, and I think she referenced that. There's no time limit, is there? Or can we waive a time limit if the evidence becomes available?
The commission does have the authority to waive the time limit, which is 6 months after the final decision is made. So if the commission determines that in the interest of administrative efficiency or justice, that a waiver would be appropriate, then the commission can do that.
She didn't authorize it already, though, right?
No,
Okay.
Usually the hearing examiner will consider that issue, and in this case, I don't know if she did, but she did not waive the 6-month requirement.
Okay, thank you. Seeing no other questions, we will move into testimony. So we'll go ahead and start with the tenant who appealed the decision. And like I said, if you could state your name for the record, and then how would you like to divide your time? You have a total of 5 minutes. And
I would do like 2 minutes and then 2 minutes or 3 minutes for your questions.
well, it won't be necessarily for our questions. We won't take time from you for our questions, but for your
the rebuttal.
presentation. Yeah, after the landlord speaks, then you'll have a segment of time left over. Do you want to do 3 and 2? Or?
Yeah, that's fine.
Okay.
That's fine. Yeah.
And then if we just ask, you heard the discussion, if we could just stay no new evidence, and we'll go ahead and.
Right, yeah, yeah. Rod Cradaville, I live in West Hollywood, obviously. But I wanted to go back to the part where Eddie, the code compliance guy, came in, and he basically said that the way that they had it put was not up to code. He didn't say that it couldn't be done, because the way I had it before is I had the heater vented into my bedroom and into the rest of the apartment. So all I wanted was it to vent into my bedroom. The way that they did it was not done properly. He said it could be done properly, but the way they did was not up to code. So that's why they patched it up and then put in the baseboard heater. The other part about the dog, my dog sleeps with me at night. So I close the door if I have visitors because I don't want him going back and forth. And it happened after her determination on the 30th or whatever. That's when my dog burned his tongue. I know I can't do more evidence or supply more evidence, but that's what happened after the determination. So I would ask that you do provide that waiver so that I could present that evidence from my vet, evidence from my gas bills and electric bills showing that the price is a lot higher that I'm paying now than I was a year ago today.
Do we have any?
That's it.
Then, do we have any questions at this time?
Just one were you ever told that the vent could not be used because the new unit is electric and the old unit was gas?
No, the new unit also is gas. So, but it just doesn't vent into my bedroom. So when they closed up the vent, that prevented any type of heat coming into my bedroom when the door is closed.
And do you know what it needed to make it work like it used to?
Yeah, a correct vent, a correct, I guess, outlet to vent into my bedroom.
I see. Thank you.
Thank you. Any other questions? All right. Go ahead and have a seat, and then we'll have you use your remaining time after the...
Thank you. Thank you for your
Thank
service.
And the property owner, would you like to come up to the... You'll have 5 minutes. If you could start with your name for the record, and then we just ask that you also don't present any new evidence and respond to the issue at hand.
Thank you, gentlemen.
Thank you.
The initial heater that was
Your name first, I'm sorry.
Elliot Wachtel Encino. Thank you. The initial heater that was in his unit initially was 50, 60 years old. They don't make those heaters anymore. It was replaced by a 25,000 BTU unit, which is far more efficient and heats two-bedroom units that I have in the apartment now. Rent stabilization compliance required me to close off the unit in the bedroom and put in a wall unit on the floor. I did exactly what they requested. I can't do much more. Thank you for your time.
Thank you. Before you leave, just make sure, do we have any questions?
Yes, sir. Was there ever discussion that by the code enforcement inspectors that the heater was not placed properly, or any indication that the installation was not done correctly?
No, it was done to code.
And after you completed the installation, was there re-inspection?
There was re-inspections. I think there was 3 inspections on the Williams unit.
And there was never said any mentioned anything that could have done differently, that should have been vent left open or anything like that?
There is no other unit available today to replace what was in there 50 years ago.
All right, thank you.
Any other questions? All right, Sina. Thank you, sir.
Thank you.
Yes, go ahead. And you have, how much time does he have remaining?
30, I can do it in 30 seconds.
Okay.
Yeah, okay.
Yeah. Eddie Esparza was the code and compliance officer. He's the one that came into my unit. We talked. He said if he puts a gas unit, separate gas unit, right where the vent used to be, that would solve all the issues. So I wouldn't have a baseboard heater where my dog would essentially get in, dogs do what dogs do. And that it basically wouldn't be an issue.
Great, thank you. Do you have any questions? All right, go ahead and have a seat. Thank you very much. We'll begin our deliberations. Would anyone like to begin? Can I, if it's all right with everybody, I would like to just start by reminding everyone that, so the hearing examiner in this case was asked the question of whether she ordered that the heat be accessible in that room. That was her order. And then with the evidence provided at the hearing, or in when she determined that that there had been enough evidence that the heat had been returned to the room, that is when she issued the compliance. And so that's kind of what we're focused on here, is whether the heat was returned to the unit. Would anyone like to begin?
Yeah, and also that we're limited as an appellate body here by the evidence that was presented at the hearing. So certainly we're sympathetic to hypothetical evidence of a safety hazard or a dog being injured or increased costs. Those are all very valid evidentiary things that could be submitted to change the hearing examiner's position. However, as an appellate body, we are limited to the evidence that was presented at the hearing, and therefore we can only make a decision based on, did the landlord comply with the hearing examiner's direction at that time? So I'd be inclined to, of course, move to, go with the recommendation of the staff. However, I am also persuaded by the waiver period and seeing if that new evidence could be submitted to the hearing examiner to, change the decision or rectify a situation where, if there are increased costs, or if there was a dog injured, or if there are safety hazard concerns that weren't presented, that those could be addressed. But seeing as though our job as an appellate body is to look at the evidence as presented and determine if the hearing examiner's decision was an error, I can't determine that the decision was an error based on the evidence presented.
Thank you. Who would like to?
Yeah, I agree. I agree that as an appellate body, we should give deference to the decision of the hearing examiner. We really shouldn't substitute our decision for his or hers in this case. Although I am moved by the tenant's dilemma. You know, if he has a dog, you know, I feel for him that I hate to see the dog keep getting hurt on the baseboard heater. But I do see that the heat was restored to the room, and I think the hearing examiner properly found that there was compliance with the order. Therefore, I think we're compelled to affirm the hearing examiner's decision.
Anyone else? Commissioner Agassi?
I'm a little bit troubled with this because on one hand, I see the compliance by the landlord, the replacement of the heater. On the other hand, clearly the heat doesn't go directly to the bedroom, which was, my understanding was the order from the examiner. The dog issue, yeah, clearly we can recommend a waiver for that 6-month bar to bring up the possible safety hazard to the dog or any other safety hazard issues so that the tenant may refile. But at the same time, if this was an old unit and there is nothing comparable to find in these days, that would be exactly the same type of heater that was 50 years ago or so many years ago installed. So I guess at this point I'd like to hear maybe other commissioners' comments.
Would anyone like to go next?
Well, I believe the landlord did comply. It's not for us to redesign the room or the heating system. I am sorry about the dog. I don't know how any of that could be rectified. That part is a little perplexing for me. But I would say I'm pretty much in agreement with the rest of the analysis.
Commissioner O'Keefe?
I tend to agree that it sounds like the landlord did comply with what restoring heat to the bedroom. The evidence about the dog actually being injured wasn't presented because it hadn't happened at the time of the hearing. Whether or not, it sounds like the landlord was told specifically that he could put in a baseboard heater, and he did so. So I would be sympathetic if that were then found to be a reduction in housing services. But then again, for purposes of the tenant, the dog was injured possibly. So it seems like it might be appropriate in my mind to affirm the decision, but to waive the 6-month time period so that it could potentially be reviewed again.
As to the waiver of the time, I'm not sure, maybe staff can comment, but typically a waiver is given so that the tenant can file a new application for a rent reduction. Is that something that can be done on a compliance determination?
That would be a completely new application. I mean, once you act on this, this is the final decision as to this application, the original application and decision and compliance. If information that the tenant couldn't have brought at this time of the original application can be submitted at a later date, it would be a completely new application. But he would also have to show the hearing examiner that it couldn't have been brought at the time of the original application, which, based on the discussions here, it sounds like there's some evidence that wouldn't have been available at that time. But this would not be a waiver of a right to challenge this determination. It would be a new application.
And this isn't an appeal from the original hearing examiner's decision, so it wouldn't be appropriate to do a 6-month waiver because it would be ineffective because that's not the issue on appeal.
You know, I think that's right, actually. And the original application, I don't know when that final decision was. I'd have to check the record, but it might actually be past 6 months already. So that is true. Yeah.
I don't think I understand that answer. I guess when I'm referencing the waiver, I'm referring specifically, or I would be supportive very specifically to the bills in the gas versus electric that the hearing examiner specifically mentioned. If you can provide me this, then, because she makes the assumption that because the new heater is more efficient than the old one, but there's also an electric heater that increases cost, she makes the assumption that they cancel each other out and offers to the tenant that if you can provide me a bill that shows the difference, you can refund, or he wasn't able to at the time, and then she continues on to say that you can refile to show that there has been a reduction in, or that the service wasn't fully restored. So that's where I would be going with the waiver, as to if he gets his next bill and realizes that because he's been using the heater, although this is a bad time of the year to really evaluate that, so maybe it'll be 6 months before he's able to show that, but to compare those bills from December to December, what the difference, the offset was, and if it comes out to the same, then there's no issue. If it's substantially different, substantially increases his costs, that would be a reduction in service, and he shouldn't have to wait 6 months to show that.
Right, and there's two issues, and one, Commissioner Gregor is correct that the 6 months waiver really isn't necessarily the requirement that an application not be filed until 6 months after a final decision probably isn't even relevant here. I'd have to check the date, but the final decision on this was already rendered. This is a compliance determination, so it probably isn't even an issue anymore.
So it doesn't apply to compliance?
Right.
Okay.
And the second issue is whether or not the evidence was available at the time of the original application, and from what it sounds like has been discussed here, it probably wouldn't have been, because there needs to be a gap between the installation and the experience of how much it costs. So I don't foresee any procedural problems for the tenant if he refiles.
I understand.
But for tonight, we're just focused on the compliance determination issue for the hearing examiner's decision in the original application, which was restore the heat in the bedroom.
Correct.
And that was done, yeah.
It seems to me if there isn't, I don't know about the safety issue, but I don't know if this is something that the tenant could speak to the city code compliance to make sure that the unit is in full compliance with the law at this point. But it just seems to me that the hearing examiner decided that the heat was restored, and we have to affirm that decision. And I just don't see how the 6-month waiver is even possible to impose here. Once rent is restored, it's restored, and the increased cost actually has no bearing on whether heat was or wasn't restored to the bedroom.
I would disagree with that last statement, because they actually discussed that, and she specifically said, if you can show me that the service has been decreased based upon the cost, that would be a factor, but he just wasn't able to provide either wasn't able to or didn't provide the evidence. But I think I'm understanding that this isn't relevant, a waiver wouldn't be relevant in this case anyway, because he's not required to wait 6 months for a compliance determination.
If it's a new issue.
Right.
Yeah, the issue's kind of moot, basically.
Yes.
Great. Yeah, with new evidence, he can present a new application for rent reduction, and we can rest assured that we can do our job as an appellate body and not be waiving not be moving or disabling his rights to bring a new application.
Are there further comments? Vice Chair?
So the issue before us, I think, came about because the furnace was installed, well before cityhood. The building was probably built when this is unincorporated Los Angeles County, and whatever building codes were in place at the time may have been applied a little loosey-goosey, for lack of a better term, and the codes have evolved. So the landlord replaced a malfunctioning unit with one that was to the code of the City of West Hollywood. The City of West Hollywood required that vent to the bedroom be closed off. The landlord then restored the heat to the bedroom just in a different manner than previously. So I think, agreeing with my fellow commissioners, it's a very narrow focus here tonight. Was the heat restored? There's nothing in the record that shows that code compliance came back out and signed off in the installation of those baseboard heaters. Again, there's no evidence of utility bills of these are my gas electric for the last year, and here's what it's been since then. So we're merely focusing on that narrow question of was the heat restored. And from what I can read in the record, it's different than before, but the heat has been restored. So I would vote to affirm the hearing examiner's decision.
Yes, Commissioner Topchin?
Because I had questions, and I'm reading the order, which specifically states provide substantially the same amount of heat in the bedroom. Now, yeah, based on the language the examiner used, I don't know how to measure if there was the same amount of heat provided to the bedroom. It's if it was me, I would probably use a different kind of a statement or the language, but nevertheless, at the end we have the landlord's substantial compliance by replacing the old heater and installing the new one. I would, and the examiner who wrote the original order, then she found that the owner is in substantial compliance and ordered the compliance determination. So I would probably, I'm ready to consider supporting staff recommendation that there was substantial compliance by the landlord by replacing the old heater. However, again, I want to make sure that any other issues regarding to the safety or the bill, electric bill, or the gas bill, or the dog safety, so for the tenant to be able to bring this up. So I see the application, the original application was filed in July of 2017. If it's accurate, again, it's in the procedural background. Now, I just want to make sure that if we're not going to include the waiver language, then in our resolution, so then I just want to make sure that that is correct, that we count from the original application date and not for example, when the decision was issued, which is March 2018, or any other technical thing that would prevent the tenant to bring up this issue within the 6 months. So I guess if we could check on that before we can vote on the final resolution, whether to include the 6-month waiver or not.
Well, the commission was discussing, I looked up the specific regulation that governs the filing of applications, and there might be some ambiguity about what constitutes a final decision, whether this decision tonight constitutes a final decision or whether the original application, and it's not stated directly. The provision it relates to the applications in general, but reading it more broadly, it could be interpreted to mean final decision, including like a decision that you're making tonight. So if the inclination of the commission is to allow the tenant to file, should he choose to do so, and wants to avoid any ambiguity, then you can move to waive the 6-month filing requirement just out of an abundance of caution.
Great.
That's up to the commission. It certainly doesn't create a, if that's what you want to do, then you can do that. And then if you don't, and there's a subsequent interpretation of the regulation that would lean towards the other conclusion that the application is the only thing that can, the original application is the only thing that can be relied on, then at least you're not jamming up the tenant. So it's up to you, and it's up to you whether you want to resolve that ambiguity and waive the 6-month filing requirement.
Thank you, Mr. Hollow.
Thank you.
Do you have a question?
Legal question. Would we have the ability to remand this back to the hearing examiner because she brought up that issue of the utility bills?
I'm sorry, what was the last part of the question?
Since the hearing examiner brought up during the hearing the issue of if there had been utility bills or something along that line, or the vet, do we have the legal authority rather than affirming the decision or denying it to just remand it back to the hearing examiner?
I would recommend against it. I don't think that in this case, that was an offhand comment by the hearing examiner. It didn't suggest that there was anything, it doesn't suggest there's anything defective about her decision that she reached in any way. It's just that I think she was pointing out that that evidence could have been weighed had it been presented, but it wasn't. It wasn't presented, and the decision is supported by substantial evidence, and the tenant failed to rebut the presumption that the order had been complied with. And so I don't think that that would be an appropriate basis for remand.
And then secondly, if the tenant wanted to file, again, wouldn't it almost be separate issue than what we're deciding tonight, as far as the increasing utility and danger to the dog, because we are deciding only on the restoration of the heat. If there are other issues, I'm not sure we would need to waive the 6 months because it's really those are separate issues than he originally filed.
So you're asking whether or not you would want to waive in general
Would it
for all
would it be
issues?
necessary, since it's not the issue we're deciding tonight? The issue that we're deciding tonight is just on the restoration of the heat to the bedroom.
Right.
Nothing else. So would there even be a need for a waiver, since the tenant may or may not want to file on those other issues?
Well, regarding the other issues, the question is whether or not they could have been brought under the original application. That's really up to the commission. But since we're focused in on this one issue, I think that if you're inclined to waive the filing requirement, then it would be for this one issue. Is that the question?
No. Again, because this hearing is only on the narrow issue of the restoration of the heat, nothing else, correct?
The service.
Right, the restoration of the
heating
heating
service, so
right.
correct. So we're going to be issuing a determination one way or the other on that. So I'm not clear on why a 6-month waiver would be necessary from us this evening if these other issues, which are really separate from what we're determining tonight, it would be
I'm not sure if it's going to be separate. I'm not sure if he's coming back on the issue of the heat, that the heat has been substantially reduced in the bedroom, or it's going to be some other issue. I don't know. That's up to the tenant in terms of how he wants to frame his application, if he even applies again. But
given your explanation that the law is ambiguous, I don't want to put procedural hurdles in his way to another filing. I would be inclined to give this a waiver because I don't want to put procedural hurdles in his way. In an abundance of caution, as it's been explained to us that the law is ambiguous.
Are there any other questions? Any other comments?
I'm ready to make a motion.
Can I make,
Sure.
just real quickly, I think we're all in agreement, but just for the record, I do agree with the hearing examiners, or the staff's recommendation. My concern, I'm no longer concerned about the 6-month waiver, but I will support it if it makes the commission feel better. I understand the issue a little bit better now and don't see it as a problem, but out of, excuse me, out of abundance of caution, I wouldn't mind that being in the motion. And I think that's all I have. Would anyone like to make a motion?
Sure, so I'll make a motion to waive the 6-month period for this tenant and adopt Resolution RSC 18-523, a resolution of the West Hollywood Rent Stabilization Commission of the City of West Hollywood, affirming the compliance determination in D-4252 CD.
Right. I think they're going to have to redraft the resolution, so
Do you have
I
a
recommend just
redraft?
simply making
Sure.
a motion to affirm, but include the 6-month waiver.
I thought he did.
Second.
So we.
I actually wasn't
is
making
he still
that
taking the
motion because I
motion?
opposed the
Are
6-month
you-
waiver, but
Are you accepting that
No,
amendment?
I'm supporting the motion to,
We're not there yet.
Okay.
So I want to clarify, you've accepted his amendment to your motion, and you're fine with that?
Yes.
And you were seconding it, so you accept that as well? So the
Yes.
motion on the table is to support the staff's recommendation, uphold the hearing examiner's decision, and allow for a waiver of the six months. Correct?
With respect to the heater in the bedroom only, that's what, is that the substance of the motion?
Yeah.
Yes.
you accept-
Okay.
So we have a motion, a second. Do we have any other discussion?
just to clarify, I actually do not support the 6-month waiver, but I will vote yes on the motion.
Any other comments? All right. We'll go ahead and go to a roll call vote.
Commissioner Maggio,
Aye.
Commissioner Gregoire,
Aye.
Commissioner Topchin,
aye.
Commissioner Charity,
Aye.
Commissioner O'Keefe,
Aye.
Vice Chair Bergstein,
Aye.
Chair Kerpies.
Aye. All right, thank you. We might need to, but just one moment. So thank you, everyone, for both parties for being here. Hopefully that made sense, the long discussion we had. And we will, we've got a request for just a very, very short break before we move into our next agenda item, which is the unfinished business of landlord-tenant cost sharing for seismic retrofitting. Before we go on a break, there are a couple members that are going to be recusing themselves from this discussion, which will be myself. Are there any other members that will be recusing themselves from this discussion?
I am required to, yes.
Okay. And the reason I am recusing myself is because I live in a building that is rent-controlled. I'm a renter in a rent-controlled apartment that is listed on the building, or listed on the list of the 800 buildings that this would directly, or potentially could directly affect. And I believe that's the same.
Yes, the same is true of me.
Okay. So we're going to take, Vice Chair Ferguson, you'll be taking over the meeting, so we'll take as long a break as you'd like.
It's a 5-minute break? Yeah.
All right, we'll take a 5-minute break, and then we'll be back.
Call the meeting back to order. This will be dealing with item 12, landlord-tenant cost sharing for seismic retrofitting. Mr. Noonan, are you going to make a report, then we'll have public comment? How are we going to handle this?
Yeah, I'm waiting for the PowerPoint to come up. I do have a little presentation with some visuals, so the members of the audience are somewhat entertained while we... Is the lighting right? Okay, thank you. My name is Pete Noonan. I'm the Rent Stabilization and Housing Manager. I'm also the Acting Director of Human Services and Rent Stabilization right now. And I'm going to just provide a little presentation on this item. The Commission has been studying the issue of cost sharing in relation to the city's mandatory seismic retrofitting program, which the Council adopted a year ago. And some of the key questions that the Commission has been looking at revolve around the appropriateness of a direct cost pass-through, which I will get into and explain, versus the existing approach that we have now within our rent stabilization ordinance, which is to allow a landlord to raise the rent if costs at the building justify the rent increase that could be above the allowable percentage that's otherwise allowed as a pass-through each year. So just to give folks a sense of what we're talking about here, and I'm not sure that the slide to me looks a little bright, so maybe we could get the lights turned down a little bit. That'd be great. I can describe that. There we go. Thank you. So there's two ordinances that the City Council adopted, one of which is referred to as the soft story ordinance. And there's a good visual here on the slide of what a soft story building looks like. There are many soft story buildings in West Hollywood, and on our list of the survey that an engineering company did for the city, which is a visual survey, meaning that they drove around the streets of West Hollywood and they identified buildings that look like they match a certain architectural style or form. So there's no indication or determination or suggestion that if the building is on the list that it in fact needs seismic retrofitting, but that it is matching a certain architectural style. Now, that being said, when you see the word soft story, what that means and what it's really referring to is this lower section here, you can see in the upper image, that has collapsed, and the collapsing is most likely due to the weakened or the small, weak support structures that really didn't have enough strength to hold the building upright during a major earthquake that has strong sesh waves which are moving back and forth on the ground. And so this building essentially pancakes. The remedy here in this particular case is to add steel I-beams at certain points underneath the building. So in fact, there's no work that is done within the building or within the units. It's all done within the parking area, within the storage area. And you can see this happening now around us in the city of Los Angeles. There's several buildings in Hollywood that are undergoing seismic retrofitting of one form or another. I do apologize that I don't have photos. I did take some photos this morning, but just didn't have a chance to load them up and present them. But I can tell you, if you want to grab me after the meeting, I can tell you a couple of addresses to look at if you're at all interested in what this really entails. So, on the soft story ordinance, which is now in effect, the first step would be that the landlord receives a notice from the city. Nothing is expected to happen until that notice is received by the city. Once the notice is received by the city, the property owner, the landlord, will have 5 years to submit documentation to the city's satisfaction that the retrofitting has been completed. That may entail simply submitting the documentation that it's been completed. If the work has been completed, it's been completed. The work that property owner has done. If not, then the property owner would contract with a structural engineer, and the structural engineer would issue a report that would be submitted to the city, and then with that report or subsequent to that report, they would submit a plan that would show how they're going to address the situation. That would all be reviewed by our building and safety office and a contracting engineering firm that we've retained to look at these plans, Dag and Kalb engineers. And then the work would be completed, signed off, and that owner is then compliant with the ordinance. For the non-ductile concrete pre-Northridge steel moment frame buildings, it's a little longer, and that's because these buildings are bigger, they're more complicated, their structural wherewithal is more complicated. I've described these buildings as the big pretty buildings in the city, and our building engineer, our building official hasn't said no, that's a bad way to describe it. So I'll keep describing these buildings as such. Importantly also to note that many of the condo buildings in West Hollywood are of this structure, or the buildings that were on the list are of this means. Now, condos in the city of West Hollywood that do happen to be non-ductile concrete or pre-Northridge steel moment frame were exempted from this ordinance. They were not exempted from the soft story ordinance. And so if there is condos that do fall within the soft story ordinance requirements, those will be brought up to code. Okay, so the only major difference in timing is the timing between these two ordinances. This ordinance requires 20 years for the owner to be compliant, and that's because the approach, the technique, the style, and ultimately the retrofitting that needs to be done is much more complicated in these buildings than it is in the soft story. Okay, so this all, I'm going to give you a real quick, we're starting at December 18th when we came to the council and we brought an update forward to them, and we told them that we were initiating this conversation on sharing costs for seismic retrofitting. Partially, a real concern from staff at that time was the concern over the potential for rent increases and an inability at our level, with the current approach that we have within our ordinance, that we are required to have within our ordinance by law, that we would not be able to exempt any tenants that could not afford those rent increases from incurring that rent increase. Now, we also acknowledged that Costa-Hawkins in 1996, it allowed for rents to be set to market at vacancy, and in fact, there is an ability and a potential for landlords to make and earn a profit higher than otherwise they could if the existing tenants remained in their units. And so there is a real balance between the two. Ultimately, we saw a real need to preserve our rent-stabilized housing stock. In a major earthquake, if the buildings come down, the property owners can rebuild. The new buildings will not be rent-stabilized. And so without seismic retrofitting, the re-engineering of buildings, the people that stand to lose are the tenants and the city. So what we've done so far, and recently on May 9th and May 14th, we did hold 2 additional community meetings. We had held meetings in February as well. In addition, we had held 3 meetings on housing in January and February. So to date, we have held 7 meetings where we've shared this topic with the community, but by far and large, these last 2 meetings were the most directed and focused of those meetings. We had over 125 people attend the May 14th meeting. We had over 75 people attend the May 9th meeting. In addition, we've released an online survey. We've had about 400 people participate and take that survey, and we have maintained our website and kept that as current as we can for events and activities. We've also provided 2 direct mailings in the form of postcards, and I think I saw a couple folks here tonight with these. So this is the most recent one. It's in green. Our next mailing will be our rent stabilization newsletter, and that will go out at the end of this month or the beginning of July. So why rent increases or pass-throughs? Again, as I pointed out earlier, if the building costs are more than the rent, landlords can raise the rent, and that is part of law. The rent increase is 100% of those costs, and it's permanent. It is a permanent rent increase. The new AGAs are based off of it, and there's no waiver that's possible, and tenants will have to pay. A pass-through, however, allows the city to set a monthly payment that's capped per month. We can do that with a pass-through. It goes away after a set number of years if the city so chooses, so it can go away after a certain number of years, or after a certain percentage of the project has been achieved or been reclaimed by the property owner, and a hardship waiver is possible under the pass-through scenario. The real difference between these two, now these slides do tend to repeat themselves a little bit, but I just wanted to point out that at the very bottom of these slides, the real difference between the possible rent increases and the pass-through. Under a rent increase scenario, under the current law in the city of West Hollywood, the landlord does have to justify that rent increase, and so they would have to provide substantial documentation indicating and validating that they do need the rent increase to meet the net operating income at the building. The pass-through scenario, the landlord does not need to justify. They would be allowed to pass that through under the requirements and the parameters that are established within the city's program. So what we're really looking at here and what our real concern is, I think captured very well in these slides that our consultant, Kaiser Marston Associates, did for us, Kathy Head provided. And when we look at these slides, I really want to, let's zero in on this last column here, which is a slide that's the column titled Low Rents. So when we look at the NOI example and how this could impact and the potential or the concern that we have for rent increases, we looked at 3 different building by rent. Now, high rents mean that there's a lot of tenant turnover. You have new tenants every year, every 2 years, every 5 years. There's long-term tenants are not living in this building. A mix of tenants means that there's some tenants, they're old-timers, or just long-term renters in this building, and a mix of short-timers, or the building's turning over somewhat, but there's still some people that are remaining. The low-rent buildings are those buildings that have had people living in them for a while, for more than 5 years, 10 years, 15 years. When you look at what happens here is that the differential, if you will, between the rents that are achievable in the building and the costs, it gets greater. It narrows, if you will. So the costs and the rents start matching. And partially, that's I think you could see this as the bonus or the bright side of this for the people living in the building is that this is essentially the tenant's equity. That the increases are bound by a specific rent increase. This last year it was 1.75. The year before it was 1.25. I believe it was 0.75 the year before that, and it was 1.25 the year before that. And so this is, if you will, equity that tenants receive off of the rent stabilization program, and we find this to be very powerful. This is the way that people are able to remain in West Hollywood. When West Hollywood is improving and it's becoming a nicer and nicer community, and the new rents are going up and up and up, those rents on long-term tenants remain low. The concern, though, is that when you have something like a major structural redo of a building, that the cost in the building can go up, justifying the need for a rent increase, and those rent increases can be large, as you can see in our example here, $100, $107 to these tenants. The simple reason for that is because the rents in the building are low. That means that the building has had a number of long-term tenants. We want to keep our long-term tenants in West Hollywood. And so knowing that we don't have a way of exempting or waiving those rents is really what drove staff to propose and really bring this forward to the council and bring it forward to the Rent Stabilization Commission. For the audience, I believe that this is a real driver and a reason why the Rent Stabilization is taking this seriously and reviewing this. Now, I want to just touch on these other two columns because I think that they're on the slide. It's worthwhile. I don't want to just focus on one and ignore the others. In a building with mixed rents, you could imagine perhaps what happens is that the rent increase goes down. The potential for a rent increase goes down. And the reason that that's happening is because Costa-Hawkins is allowing, with vacancies, the landlord is able to raise rents higher, and then they're locked in again. But that changes the income to the debt that's in the building. In the buildings where there's high turnover, you don't really have a possibility for the rent increase. And even under a capped, a pass-through scenario, that would be the same, because we looked at a number of programs across the state, and those programs, the cap went away when you had tenancies turnover. So but again, I want to be, we should be aware and cognizant that in the high rent scenario, that means that tenants are moving where you don't have a real risk of rent increases. So it's in the buildings where you have tenants that are staying long-term that you have the concern or the risk of a rent increase. So the alternative, as I mentioned, the pass-through, what this does is it just simply sets a cap and says, landlords, property owners, for instance, in option A here, we have two options. We looked at two options for the real differences between them is right here, is one of the main differences. It's just simply the percentage of the project that you can pass through. We looked at B as 100% of the costs, A as 50% of the costs, and then there's a couple other changes as well, but that's really the main change is right here. In this case, option A, we'll just focus on that. This says property owner, in this calculation, you're able to pass through for 30 years. I mean, that can be 10 years, can be 20, 15. It can be adjusted and changed. Landlord, you can pass through 50% of the costs. And on a 10-unit building, this is what we estimate those costs to be. And this is what the per month cost would be is $41. But we're going to cap that cost at $38 a month. And so the tenant is going to experience a $38 a month increase. That's separate and apart from the AGA, so it doesn't go up with the other rent increases that take place over a period of time. And that at the end of the period that it's in effect, say if it's for 10 years, it goes away. That means if that tenant stays in that unit for that period of time, they do pay the pass-through, and then the pass-through goes away. We have an assurance, a greater assurance that that building is seismically retrofit and it's going to withstand a major quake, a quake that would take the building down and remove rent stabilization from that property. Okay, so on April 2nd, the last time we went to the City Council, the day after the soft story ordinance took effect, the council directed staff to continue to look at the appropriateness of a pass-through. They listed out a number of things for us to look at, limited to a percent of cost, capped at a maximum dollar amount per month, in effect for a set period of time, and to explore including a financial hardship exemption. After that council meeting, we released an online survey. We also held public meetings, and we went out and we talked to people. And as you can imagine, most tenants were either extremely uncomfortable or uncomfortable with a possibility of a rent increase. And we did have a couple people that were very comfortable with it, and one or two that were neutral. But by far and large, people were uncomfortable to extremely uncomfortable with the possibility of a rent increase. Additionally, as you can see, most people agreed with the idea of having a hardship waiver for extremely low-income renters. We want to keep our community whole. We want to keep our renters intact. So as you can see, most people strongly agreed with it or agreed with it. There's a couple that didn't agree or they were ambivalent to it, but by far and large, people thought that we should have a hardship waiver. Now, when we asked about the idea of how much a pass-through per month should be in place, most people said other. And I'll tell you that about 60% of people said no. They said zero. But 40% said, yeah, there should be a pass-through, with most people saying 30%, which was the lowest option that we had in the survey. Now, most landlords said 50%, which I think was the highest option that we had in the survey. I don't think there's any surprise there. But I think that there's some value there, that 40% said yes, pass costs through. We do recognize that people are concerned and they're fearful, and that although if you fear a rent increase and you don't want the pass-through, I think that in this case there really needs to be one or the other. So staff's assessment is based on the outcomes of our community meetings and the survey responses that a cost pass-through would be appropriate and capped at a rate between 30 and 40%, or $30 and $40 a month, limited to 50% of project costs, in place and in effect for up to 10 years, or that 50% cost maximum, and that we establish a hardship waiver. Now, on April 2nd, the City Council also directed the Commission to continue analyzing actual cost of retrofitting and whether the pass-through is appropriate, whether the current rent increase process is sufficient, and to provide its recommendation. And so if the Commission is, that we'll be deliberating and discussing this tonight, and the outcome may be a proposal. This evening, the Commission will not make a final decision, but could potentially make a proposal that we will share on Saturday at 11 a.m. in the West Hollywood Park Auditorium, and then that we will continue to share that for a month until July 12th, when the Commission again picks up this item to consider a final recommendation. That concludes my report. I'm available for questions, as well as our consultant, Kathy Head with Kaiser Marston and Associates.
Before I ask my fellow commissioners if they have any questions for staff, are there any other members, that's bright, any other members of the public that wish to speak tonight that have not filled out a speaker slip? Victor, I don't see a slip from you. Come on up. So anybody who wants to bring it up to our secretary, please. So any of my fellow commissioners have a question on what staff has presented? We'll have our comments later.
I do. I've wondered, like many of the residents in West Hollywood, why the pass-through option isn't presented with an option to justify that from the landlord's perspective. I think I think it's a valid question that's come up in a few of the town hall meetings. So I just wondered why it's presented without the option to justify their need for a pass-through.
The justify under a cost pass-through scenario is the actual project costs. So a cost pass-through is a pass-through of actual project costs. The landlord would be providing those costs, and in the assessment that I provided on the staff slide, it would be 50% of those costs submitted for the project would be eligible for the pass-through. So as opposed to looking at incomes and income at the building, which is the net operating income approach that's used in our rent increase process, the justification for a direct cost pass-through is that the landlord incurred the costs and is then sharing half of, in the example, sharing half of those costs with his tenants, his or her tenants.
Questions for staff?
Just a quick one. Mr. Noonan, the survey is closed now at this point, or people can still go online and...
People can still go online, and we will still collect those surveys, and we will provide updated outcomes of the survey on July 12th.
Okay, thank you. And where the list with that buildings potentially to be retrofitted, where people can find those addresses?
Yeah, we're maintaining all of this information online at www.weho.org/seismic. And if you have the green flyers, it does have that web address on the back of it. I do have extras up here if anyone would like one. It's www.weho.org/SEISMIC. That's seismic.
Thank you.
Questions for staff? I have two. One, I can't quite wrap my head around one portion. The chart that you showed for the pass-through under the 50% recovery and 100% recovery.
Go ahead with your question.
The question I have is it's showing as, let's go with option A, it's showing a pass-through per unit of $38 maximum, or it says, excuse me, on the right-hand side, $30 or a 10% increase in rent. So would it be, let's say someone's rent is $1,500 a month, so that option B, $30 increase could actually be $150 under that 10% increase in rent, because it says whichever is greater.
Yeah, no, that's an accurate assessment. I think that you rightfully, astutely picked up on that. So these are two different programs that we looked at. Option A is really a very similar program to what's in place in the city of LA. And option B is in place in San Francisco. And in the San Francisco program, it is $30 or a 10% increase in rent, whichever one is greater. So in that particular example, where you have a $1,500 rent, I believe it'd be $150 increase, and that's in San Francisco. Now, when staff assessed the programs, we looked to LA. We see that LA is working, and it's all around us. And so rather than looking at other models or examples that are outside of the greater region, we looked to the Los Angeles model, which is just simply a flat cap at $38.
Second question is kind of a policy wonk question. I think it's under the NOI scenario that increase would go away upon new tenancy, because under Costa-Hawkins, rents can go up. So my policy wonk question is, and this is all hypothetical, but there have been enough signatures submitted, so there may be a ballot initiative this fall that would repeal Costa-Hawkins, returning rent control to the local jurisdiction. I'm not sure what that means. But if the scenario were to unfold where there would no longer be rent decontrol upon vacancy.
Okay, so let me take it a couple things that I heard, and then Kathy Head's going to jump in with the other question.
Please do.
So,
okay.
Yes. What I heard, A, is that it goes away after a certain amount of time related to NOI. And okay, good, because I just wanted to make sure and be clear that under the pass-through, it does go away. And under the NOI scenario and the new rents, of course, if you have a new tenant move into the unit, yes, that of course goes away, because now it's a new tenant, a new rent, everything's new. We want to keep the existing tenants in place. Under the auspices, if Costa-Hawkins was repealed, and what we had on the books originally was at a vacant unit could be increased by 10%, and then it was adjusted by AGA going forward thereafter. And so we would have to, I believe we would have to amend our RSO, our rent stabilization ordinance, to reenact the original requirements, or the original approach to rent stabilization that we had before Costa-Hawkins. And if we were to do that, then we would go ahead and establish something similar to that. Now, that NOI process would become more present, because we then no longer have the adjustments in the buildings that would otherwise be happening under Costa-Hawkins. And Kathy, did you want to touch on the other question?
Yeah, can we go back to the other slide?
course.
That's the pass-through slide.
Hopefully I didn't screw it up too bad.
No, you didn't at all. I just wanted to make the point on the $150. It would also be capped by the actual cost amortization, which in this was 82.
Say that one more time, please.
Okay, so what it is the maximum, the cap is 10% of the rent.
Correct.
Increase, but it's bound also by the amortization cost of the costs. So if you look at the chart, you'll see that the monthly amortization of $9,800 is $82.
Right over, if anyone can see my cursor here, I'm circling the $82. So there.
See what I'm saying?
Yep. So even if the rent could be increased, if their rent was $1,500, excuse me, the rent could not go up $150, because the amortization, excuse me, is at 82?
Correct.
Thank you. Any questions for staff? Okay, we'll go into public comment. I apologize in advance if I butcher anyone's names, but when I call your name, please come to the podium, state your name and city of residence. You'll have 3 minutes. No raising of the hand. If you want to put in a speaker slip, you may, sir. The first speaker is Marilyn Nelson, to be followed by Derek Woolley.
So which one of the
And just a reminder for everyone speaking, speak as close into the mic as you can, just so we pick everything up.
Okay. Yeah, my name is Marilyn Nelson, and I say hello to all you commissioners tonight.
What's your city of residence?
West Hollywood. I've lived in West Hollywood for 16 years, and two things attracted me to West Hollywood, and one was, of course, the rent control, and the other is, as I was here for the 16 years, is aging in place. And I'm now 74. I'm on a fixed income. And of course, my concern is I looked at the website, and it was talking about, at that time, 12%, and which would take me up to like over $130 a month more. And I simply could not live here. That would be it. I would be just booted right out. And I definitely don't think that that's a progression for West Hollywood at all. I appreciate you explaining all these different things I didn't realize with this. But, I was wondering too if the owners of the buildings, I mean, we do pay the rent, but they also get insurance. If something did happen, they would get insurance for it also, and they would also they get tax breaks, and just for their expenses. And I don't know if I'm sure this has been figured in as things go, but I don't think that's just entirely fair on my end, having to fix an income and things. But just be very careful about the seniors, because I mean we don't have the opportunity to change the fixed income and find another career or anything else. This is where we want it to be. So anyway, thank you so much.
Thank you. Derek Woolley, to be followed, excuse me. Sir.
It's not easy getting old, I'll tell you. And my hearing is kind of shot, so I didn't
What is your name,
pick
sir?
up a lot that was going on.
What is your name, sir?
Can you hear me?
I can hear you.
Too much?
What is your name, sir?
Derek Woolley,
City of residence? Where do you live? What city?
8919 Santa Monica Boulevard. I've been there in that building for 38 years.
City of West Hollywood.
In West Hollywood.
Thank you.
Yes, sir, I love West Hollywood, despite what they're doing to it. Now, all this mumbo-jumbo disguises the point. Should we even be considering that tenants should be helping the landlord pay for retrofitting or repairs? No, we should not. The landlord should have the wherewithal to set aside the rents which are paying for retrofitting. He should set aside the rents for repairs. A certain amount of money should go for repairs. I mean, I can't help it if he goes off to a resort and spends 6 months there and doesn't have the money for the retrofitting. It's disgusting that you people would even consider that tenants should help landlords my landlord makes at least $200,000 on the building that I'm in. And he's got so much money, he can afford to hire a management company to take care of the building for him. And you think that people like this, with hundreds of thousands of dollars, need to ask tenants to help pay for retrofitting or repairs to the building? It's disgusting. I think it's a ploy by the landlords to get around rent control. They don't like rent control. They want to raise the rents as much as they can, and they can't with rent control. Now, the first landlord that was in the building that I lived in, he had retrofitting done to the building, and it must have cost him a small fortune. He didn't ask us to pay for one penny. He paid for it because he was an honest businessman, and he knew that he should have set aside money for retrofitting and repairs, and he did. And then when he put copper pipes in the whole building, which cost him another small fortune, he didn't ask any of us to pay for it because he was an honest businessman. Am I getting through to you my point? That we shouldn't even be considering tenants to help pay landlords who have more money than they know what to do with? I think I made my point. Thank you for listening.
Thank you. Can you hold your applause, please? Eric Larson, to be followed by Britt Sans, S-A-A-N-S.
Hi, everybody. I'll come back here. My name is Eric Larson. I live at 802 West Knoll Drive, apartment 105 in West Hollywood. And West Hollywood has been my home for since 1980. I'm a senior citizen on a fixed income. I have lived in my apartment for more than 20 years, and I'm the last tenant under rent control in my apartment building. Because rents in my building have increased more than $1,000 in the last 5 years, I am not looked on as a desirable tenant. Many of us have come to these meetings because of our fears that our landlords will use this retrofitting project as an excuse to increase our rents and force us to leave our homes. I have loved this city for over 40 years. As one of those here tonight who has helped to make our city a beautiful, safe, desirable place, I am asking with all my heart that for those of us who are seniors, that the city adopts safeguards and protections, and so we can continue to live here and for the rest of our lives, if we can, and in the city that we love. Thank you very much, you guys, for listening. Appreciate it.
Britt Sans, to be followed by Victor Omachenko.
Hi, good evening. The thing I was.
You could just state your name and city of residence.
I'm
That's
sorry.
okay.
Britt Sands. I'm a citizen. I'm a resident of West Hollywood.
And move towards the microphone a little bit.
Okay.
I can hear you. Thank you.
The thing that I was reading what you put together, but you didn't mention something that is very important, and is that my landlord and many other landlords inherited their buildings. And they also have their own businesses, and my landlord is a multimillionaire. He did retrofit the building because I noticed that one of the foundations was lopsided. It took me like 5 months, and I had to call Eugene Helper to help me. And he did do it about 4 years ago. But he's got 2 apartments, two that are constantly a turnover for him. But it is scary because I am representing like 60 people who have called me, and they are on fixed incomes. $50 is too much. Some of them even $25. And when you have people who inherited the building, his father had built it in 1927, he is not hurting for money. So that concerns us, because a lot of the people have inherited their apartment buildings. And the rent next door to me is almost $2,000 for a 1-bedroom. So I really would like you to think about the senior citizens and about people who are living paycheck to paycheck, people who, these are dire times, people who need every penny. And to please consider that there are many landlords that have other businesses and they're making a lot of money. And to please consider that they have inherited this, and it's not really coming out of their pocket. It's just coming out of the rent that we put in, and they're not in want of anything. So I just felt it was important to represent all the people that had called me and to really emphasize about all these people who inherited their apartment buildings, and that to please consider these people, because some of the people will be thrown out. They'll have no place to go. And that's a scary, scary proposition. I thank you very much.
Thank you. Victor Olmachenko, to be followed by our last speaker, David Marfelstein. I hope I'm close.
Good evening, Commissioners. My name is Victor Omolchenko, and I'm a long-term resident here in West Hollywood, having been a owner, a tenant, and also in my past a government worker. So I'm looking at this from a variety of angles, and the kinds of information that I've gleaned is that in our neighboring bigger city of Los Angeles, there's over 10,000 buildings that probably need this seismic retrofitting, and they were identified. And I believe that what happened was that the rent increase was about $38 per unit. And so what I think would be interesting to know is, have a lot of people been evicted? Have a lot of people been kicked out? Did they have a hardship waiver in Los Angeles or not? What I'm hearing staff saying is that there would be a hardship waiver for folks of extremely low and low income, that would be a feature of, that's one of the recommendations that you're looking at. And so getting to the point of, the survey was interesting. I kind of jotted down the percentages, and the percentage numbers tended to hover around 80 to 75 on most elements, and 80% of our city is renters, and that's why you're hearing the concern from renters. For me, I think one of the biggest goals of government is public safety. So as a current renter, if my building were to come down and my building was on the list, I don't think my landlord would pay for me to get a hotel room or another apartment building. I would like, as a resident of West Hollywood and as a tenant now in a rent-stabilized building, I'd like to see cost sharing in a three-way angle. 1/3 from the tenants, 1/3 from the landlord, and 1/3 from the government, with that waiver, the hardship waiver for those who are low and very low income, to be there so that folks that we've heard from earlier can age in place. That's a big goal of our city too. But at this point, I think that this issue is a very important issue on the part of public safety, but I think you still need to get details. You need to see how much of a waiver you're going to get. The waiver comes out of whose coffers, and then we get on the road and start making our buildings safe, especially those buildings on those little poles that can collapse, because LA is doing it already, and San Francisco is doing it already, and Oakland and Berkeley, I think, are doing it already, and I don't want a lot of people under the rubble like there was in Northridge years ago. So I really think we need to look at seismic safety closely, and I do think that there has to be some kind of pass-through arrangement made. I look forward to your meeting on Saturday, or I think there's a meeting for the community on Saturday here in the premises for further discussion of what you may decide on today as a draft resolution, and then I guess we'll all be coming back on July 12th, and I'm really happy to hear that there's an opportunity for more people to have input into the survey, and there's still time to do that. So I encourage anybody who's listening or watching or hasn't to complete the survey. Thank you. Thank you, Mr. Bernstein.
Our final speaker is David. Help me out with your last name.
I submitted a ticket too. Hi, it's David Mermelstein, resident of West Hollywood. Originally, I was actually going to ask about offer less comment and just ask the question about who's going to shoulder the burden of the hardship waiver. That didn't seem to be discussed. Is that something that the landlord will pick up, or is it something that some sort of social services will pick up if the tenant can't? It seemed like that was unclear, or perhaps it is clear and I just didn't understand it. But anyway, I think that's something to mention. The other thing is there was a speaker here earlier that mentioned how some of these costs are borne by insurance coverage. Of course, that's actually not true. My understanding is insurance doesn't pick up seismic retrofitting. Insurance kicks in after a disaster, not before. And this, of course, is to prevent a disaster and loss of life. So it sort of saddens me this is now the second meeting that I've attended, to hear people come up, and they seem like perfectly nice, reasonable people, but state rather boldly that they think landlords are just there making money, and that they're sitting on enormous profits and huge mountains of money. And I'm just a little disappointed that people who intend to spend years living in a residence don't want to pick up at least some of the cost of their residence, the place they hope to age in place in. No one saw this coming. No one saw seismic retrofitting and the requirement that certain buildings be retrofitted. No one was able to see that, and no reasonable person anyway, and put aside money for this. Nor were we encouraged, as far as I know, and again, please correct me if I'm wrong, by the city at some earlier date to put money aside for this kind of thing. So to have this enormous cost, and it does seem to be like quite a high cost from the slides, just borne by the landlord alone, when in fact, in most cases, the landlord isn't even living in the residence. In most cases, and many other people are, it just seems reasonable. Perhaps the gentleman who spoke before me, who suggested a three-way split, that might be something worth investigating. Maybe too late for that, I don't know, but that seemed like a reasonable use of tax dollars. So anyway, that's my only comment. Thank you.
Thank you. One additional speaker, Reuven Zach.
Thank you for having me. My name is Reuven Zach, and I'm a resident of West Hollywood, almost 30 years. And I'm a senior citizen, and I agree with everything that my predecessors here said. But when there is the word sharing, or I am on my toes, when there is a suggestion to improve, say, Social Security, I am on my guards. What is cost sharing? I'm a pauper, sharing the cost with a millionaire who owns the building I live in. That's the lion's share fable. Now, the presentation was very illustrative and straightforward, but I detected some hidden parameters there. What will happen if tomorrow, next week, there is an earthquake and my building falls down? What happens to my apartment? Where will I be? What will happen if my landlord will get the insurance for a total cost, and maybe he will rebuild it, or maybe just quit, enjoy the money that he just got. Suppose he rebuilds the building. Will I still be enjoying, when I come back to my apartment, the rent control, the benevolent rent control, or will I be subjected to the devouring market? That's what I wanted to ask. Thank you.
Thank you. We have one more speaker, Lisa Dinsmore.
Hi, thank you for taking the time to listen to me. My name's Lisa Dinsmore. I live at 1147 Hacienda Place, apartment number 4 in West Hollywood. I've lived here in West Hollywood for 25 years now, and I'm 60, not quite a senior citizen, so I wanted to speak for those that aren't there yet. And I did want to say that after 20 years, I've lost my job. So I'm without income, and I can afford to stay in my apartment because of the rent control. There's 2 of us left in the 10-unit complex that I live in, and I'm grateful for the fact that I have the rent control. I'm able to live off of my savings right now. That's not going to last forever. I am trying to find a job, but it's very difficult, unfortunately, at my age. So I would like to know if, I would hope that the city, and I do agree, the city, if the tenants have to and the landlord could maybe split the cost, it might make it more feasible for someone like myself. I understand that the landlords aren't going to want to pay 100% of it, but I do, you know, for fixed income or somebody that doesn't have a job, that's where I'm coming from. So thank you.
Thank you. I believe that concludes our public comments for the evening, and I'll open it up for commission discussion.
I guess my question to staff is, what is staff looking for from the commission this evening?
If the commission finds it appropriate to craft a proposal, that would be a draft recommendation, if you will. We would go forward and share that with the community beginning Saturday and receive feedback on that proposal.
Was staff's I thought I heard a recommendation from staff in the presentation earlier. Did I hear that correctly?
You did hear a recommendation from staff, and that would be a cost pass-through with a cap between $30 and $40 a month, 50% of project costs, 10-year maximum, with a hardship waiver. And I know that there's been some questions about what that hardship waiver would look like. And part of the challenge here with crafting that hardship waiver is that when we get to the point of funds and dollars, we really get into the realm of the city council. And so in terms of if the commission did feel it appropriate to look at a hardship waiver, I think that the commission could create some or provide some suggestions on whether the city should cover that or not. Ultimately, the council would have that decision. That's within, the budget is clearly within their realm. And so, you know, the commission could recommend whether that should be explored versus having that be borne by landlords. But outside of that, you know, we would take that forward and craft the hardship and some of the other parameters, if you will, after your recommendation. So hope that provides you with enough information.
Well, I definitely think staff's recommendation, the city should continue to explore it. But it seems to me that the hardship exemption, I think, is of a lot of these folks' concern. People would like to know with more specificity, what would that hardship waiver look like? Who would bear the cost of it? I actually think staff's recommendation is generally a good one, but I don't think we have enough information with respect to the hardship exemption. So I guess my thought would be, you know, to move the process forward with staff's recommendation, but with a recommendation that the hardship exemption be fleshed out a little more, because it's hard. It will be hard for the city council to merely make an informed decision unless there's a little more, you know, there's a little more detail as to what the options would be for that hardship exemption.
I actually have concerns with the staff's recommendation. My biggest one is justification, having a pass-through with absolutely no justification. The model that we have from the rent stabilization ordinance, I feel the thinking and reasoning behind that gets it right. The upward rent adjustment that we have already has a justification in place for raising a monthly, you know, rent. And I know rent and pass-through are different elements, but to a tenant sitting in the seats, it's a rent increase. And I feel concerned, I'm concerned that we're going away from the spirit of our existing rent stabilization ordinance by not having a justification for this pass-through. I just think giving it away to somebody that doesn't need it doesn't make any sense to me. Also, I do have reservations about a per unit increase, because I think a studio is much different from a 3-bedroom. And I think one person living in a fixed income in a studio, having the same pass-through increase as a 2 or 3-bedroom unit doesn't make any sense to me. I think there needs to be a unit pass-through number that is different for those two types. I also have a concern about time frame and warning for these pass-throughs for the tenants. I am concerned that they won't be given adequate warning. I feel 90 days or more would be adequate for a person putting more money away so they can absorb what would be a monumental increase in their monthly expenditures permanently for 10 years. Now, I know that's not permanently, but 10 years is a long time. I haven't lived anywhere 10 years. So the truth of the matter is, would I even live in my current rental unit long enough to see the pass-through end? I don't know. So those would be my amendments to that. I think tenants and landlords, everybody can get behind swallowing this easier with some contribution from the city of West Hollywood. That seems to be unanimous. So if that comes through the hardship, or if that comes through some study about how the city can contribute funds to this, I think that would help the community swallow this a lot more.
Well, clearly, in my view, in my position, is that the staff's recommendation is, at least based on the survey, it closely represents what the community responded, or what the community would like to see. I understand about the justification, although that question, and if that can be clarified, that would be great. But if I have before me, if I have those options to use NOA, net operating income, rent increases based on NOA, or versus based on the that cap between $30 and $40, of course, I'm going to choose the one that is lower, that will have a lesser impact on the residents. Yes, my concern is, the primary concern is long-term tenants that are going to be affected. And for some tenants who are on very fixed income, on SSIs, that doesn't go up $30-something every year. That's $38 or $38 represents a lot of money. So it can be somebody's medication for the entire month, or could be somebody's meal for that week. That is clearly my concern. But I think that's a better model, in my opinion, than to use the NOA rent increase, which is based on this description. For the lower rents and long-term tenants, actually can be a lot higher versus if the tenant recently moved into the unit and paying a higher rent. So that's why I want to be frank that if I'm supporting, I'm going to support the staff's recommendation proposal based on the cost sharing and pass-through, the fixed pass-through. Although, yes, unfortunately, we have to make a decision as a commissioners. This is not the one that I didn't want to vote on any such increase. But if I have to choose between these two models, I'm definitely going to vote against the NOA rent increase. So based on the NOA rent increase, so I'm going to just support the staff's recommendation. But again, very important to know about the hardship exemption. I would like to see a broader kind of categories included. Obviously, it's based on the income, but maybe we can include something else. Maybe we can include the term of the tenancy. If it's a longer term, if it's a tenant who lived there for 20 years or something, maybe also included in that hardship exemption, regardless of the, maybe the income. Because the bottom line is we must preserve the long-term tenancies. That's the intent and the purpose of the rent stabilization ordinance, the very first ordinance that was adopted by the City Council in 1984. And I'm completely, ready to do whatever it takes to preserve those rent control units and tenancies in the city. So, but unfortunately, we have to take some sort of a position on this, and we cannot just hide and say, "Oh no, I'm not supporting anything." So with that said, I like what staff recommended, and I'm gonna definitely support that.
Mr. Maggio?
Well, I believe that definitely the process should move forward and as it is. However, I think it needs to be certainly refined more. One idea that I had was more of a pool concept where everyone, all renters, would pay something, which perhaps could make the amount lower. For instance, the example was $30 to $40, maybe $15 to $20. But if there was a pool concept, that maybe it could bring that number down. Again, I think the process should be moving forward for further study and further discussion.
Just before I start my comments, I'll just say that I would not be prepared to vote on a recommendation to council tonight. We still have one more public meeting on Saturday, and I think it's so critically important that as many members of the public, both tenants and landlords, have a chance to voice their thoughts before this commission makes a recommendation to council. So at the end of this discussion, I would not be prepared to vote for that. Part of this is just an update from our last public meeting. I was with Commissioner Kirby's, the subcommittee on this matter. The meeting at Plummer Park was extremely well attended. There seemed to be more tenants who were understanding the difference between net operating income and cost sharing, and that by doing nothing, the NOI would apply and there'd be no mechanism to help those who are truly low income, and the increase would be permanent. There are also more who seem to grasp if there is no cost sharing, that some landlords will choose to LS their buildings, sell it to the developer. City will then lose those existing, more affordable buildings. They will not be replaced with affordable units. The existing tenants will probably have to leave the city. So those tenants seem to grasp the fact that we need to do as much as we can to preserve our existing affordable housing stock. On the other hand, there are still quite a few tenants who feel that they should not be required to share in this cost because it's not their building, it's not their investment. We did have some really heartfelt sharings from landlords at the last meeting. We had one woman who owns a 6-unit building, and she's very much like most of our owners, where it's a mom and pop, or mom and mom, pop and pop, or one person owns one building. And she said that with all the costs that come into play for maintaining a building, not including earthquake retrofitting, that really is just a myth of landlords making this money hand over fist. We had a very heartwarming, touching story of a woman who owns 4 buildings with her family. These buildings were built by hand by her grandfather. 3 in Los Angeles, 1 in West Hollywood. She said in the city of Los Angeles, they have 2 options, either earthquake retrofit or tear the building down. Those are the only options the city of LA is giving them. She said most of their tenants are very long-term tenants. She said we look at our tenants as extensions of our family and friends, and she goes, we don't want to displace these family and friends, but this kind of a cost, if not shared, is the tipping point where they would LS their building out and sell it to a developer. We did have some questions from landlords who were concerned about contractors, that if there's going to be all these buildings coming up that need to be retrofitted, and I don't know if it would be a city responsibility to help provide a list of reliable contractors, or if that might be something that actually would be through the Apartment Owners Association. But there was concern from property owners about being gouged by contractors because there'd be so much work coming up all at once. And with the hardship waiver, and I am fully in favor of a hardship waiver, but I think that it needs to be proved up by the tenant. And by proved up, I mean tax returns and bank statements on a yearly basis. Because while you might qualify for a hardship waiver this year, the young woman, and you are younger than me, hopefully you will be reemployed soon, hopefully with a better job. Maybe next year you wouldn't qualify for a hardship exemption. So I think there ought to be a hardship waiver, but renewed on an annual basis, and you must prove up that financial need. So with those comments, again, I am not in favor of voting on any recommendation to council tonight. I'd like to hear out what the public has to say at the meeting on Saturday. Maybe my fellow commissioners have some more time for thought, agendize it for our June 28th meeting, and at that point, make a recommendation to City Council.
Vice Chair, can I add something?
Sure.
Thank you. A lot of comments we heard, not necessarily tonight, but generally, that by allowing the cost sharing would constitute sort of an end of rent control, which is completely incorrect, which is completely not true. Even if the increase would have been based on NOI, it's still not end of the rent control. So that's why having the fixed $38 monthly share, that is a surcharge. That is not really a rent increase. And if I'm not mistaken, during the annual rent increases adjustments, this $38 will be removed, and the owner will assess, the landlord will assess the rent increase after removing the $38 from the rent. That's very important to know. That's a surcharge that goes away after 10 years versus the increase based on net operating income stays with your rent, incorporated in your rent, and all annual rent increases will be based on that new rent figure. So that's why I think it is scary to have that type of a model. And that's why I feel, why I'm ready to support tonight, although I agree with you, Vice Chair, that having more input from the community is important. But if I have to choose between these two models, I'm definitely against the NOI rent increase, because that is a permanent rent increase, which I hate to see people have in the city. So I will be supporting the surcharge. Maybe things may change. Maybe the change will be for the term, for the duration of that surcharge. Maybe, something else will change. And definitely we will have a clarification on the hardship exemption. But my position as a commissioner is I'm against the NOI rent increase. Thank you.
I'm just concerned about, we obviously are all going to be in favor of a hardship waiver, and that puts an onus on a tenant to prove that they need a hardship exemption, but we're giving away a pass-through without no proving necessary for the landlord to show that they need it. And I am going to ask my fellow commissioners, I'm just going to challenge you, what are your thoughts on a pass-through with no justification for it? Don't we feel that the NOI and the upward rent adjustment application was getting it right by asking for a justification for a rent increase?
Speak to that. I understand the city's experience with the NOI adjustment process has shown that it's very difficult or impossible and not very administratively burdensome to go through that process. A number of landlords over the years have gone through that process, and they actually haven't really been able to prove their case because of the absence of base year documentation and other procedural hurdles. I don't know. I just know, I'm not 100% conversant in it. I just know that it's been over the years, the city has felt that that process is broken, it doesn't work very well, and it probably won't provide the landlord with any real relief. It seems to me that I would love it if this cost sharing would only apply to landlords that weren't millionaires, and it only really applied to the mom and pop landlords who aren't wealthy. But I'm not sure there's really a workable process that the city could come up with to really determine which landlords needed it and which ones don't. So that's why I think the pass-through probably makes sense. And as Commissioner Topchian said, the problem with the NOI, going through the NOI process, is it does result in a permanent rent increase, as opposed to something that's temporary. So I guess that's my thought about that.
And I would add to it that, Commissioner Charity, I think that if we're talking about the justification for this surcharge, I believe that the capital improvement surcharges are using also the same model for the capital improvement that also sets a fixed amount based on the expenses and based on the duration. It's used the same capital improvement model for this way of applying that, for this cost sharing. So that's why I think there is a justification, because we already have the capital improvement in the ordinance. And that's.
I'm just, I've had community discussions with the residents, and it's just a hard sell. It's just a hard sell to tell a resident that we're giving a pass-through to conceivably landlords and landowners that have tons of money already. Now, I for sure can think of arguments to counter this, saying that a resident gains a benefit from a building not falling down on them. That's clear. And I think it's also clear that we do have a ton of development around us in West Hollywood. So we do want to encourage our rent-stabilized buildings to not sell and evict tenants through the Ellis. So I certainly can think of things that I have said to people when I go to these community events for reasons that tenants should share in this. And I can appreciate that the application process is cumbersome, and maybe we would set up something where no one would qualify for the pass-through, and that's going to be terrible because buildings will be sold and people will be evicted, and that's not what our goal is. But I think you can understand my argument from the beginning, which is some people are going to get this pass-through that maybe don't need it. And that's a concern that I've heard from many of the people at the town halls. And I just want to make sure that it's heard by this commission, and we have justifications for giving a pass-through without any justification for needing it.
Let me weigh in as the sole landlord on this commission. The NOI process is cumbersome, and I think really is untenable. I'm a former paralegal. I keep meticulous records, and I would have a really difficult, if not impossible, time working through that process. As far as a landlord justifying the pass-through, these are expenses. I don't think any rational person, as I would hope, would disagree that earthquake retrofitting is paramount importance. If not, the big one's going to come someday. Do you want to lose your investment? Do you want to keep your investment? But if a landlord, a property owner, is making X number of dollars income per year above and beyond their expenses, and expenses continue to go up. I remember years ago, Councilmember Duran talked about an increase in the sewage charge because we were rebuilding the pipes. He goes, it's just a little ding. Well, the problem is these little dings and little dings and little dings to a property owner when rent is only going up a certain percentage in West Hollywood, and the annual general adjustment in West Hollywood is generally substantially less than Los Angeles and Santa Monica. So the residents of West Hollywood are enjoying much smaller annual adjustments than our sister cities. So when it's ding, 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 and then this is a big ding. This is a very large ding. My concern is that, again, if we don't find a way to make this palatable to a property owner, they will go out of the rental business. So I understand your justification going, there might be some landlords, I'm sure there are, that are making, extraordinary profits. Certainly we see there was a 10-unit building that sold last week for $3.5 billion, which to me is hard to wrap my head around. But a lot of landlords are not making those funds. So I'm not sure I would be comfortable having a justification going, well, you're making X number of dollars in profits, so you don't get to have your tenant share in, but if you're making slightly less than that, you do. So it's the devil in the details. I understand that.
Yeah, and I thank the commissioners for having the discussion with me. I owed the discussion to a few people that I've had the conversation with, and I'm sure we will all talk to the city council members that appointed us, because they will be making the ultimate decision. We're making a recommendation, but we're not making the ultimate decision, just so you're clear.
So Commissioner Bergstein had said he doesn't want to make a recommendation tonight, and I agree with that. Would it be helpful to staff if we at least made a motion to recommend staff's recommendation for further discussion and exploration at upcoming community meetings?
That would be helpful. I think that, I'm thinking that the commission would find some value in feedback from the community based on something that's a little more tangible than we've had so far. So as much as the commission can craft or define what a proposal would be, if you notice in the report, I referred to it as, I believe I referred to it as making a proposal, not a recommendation, because the formal recommendation would be coming in July. But yes, of course, as much definition as the commission could provide, I think that would be beneficial. Then that would give the community something to respond to.
Could you bring the proposal up on screen?
Yeah, Tom, can you help me out with that? So again, it was fairly simple here, but it is essentially a proposal that's very similar to what is in Los Angeles. It was a capped amount between $30 and $40, limited to 50% of the project cost, and so that's the justification that you have in a direct cost pass-through, is that you've actually paid the money, and now you are seeking reimbursement. And then that it's 10 years is the duration to achieve that 50% of costs, and that we design a hardship waiver based on a lot of the conversation, the feedback definitions that the commission has provided.
So I had one more question that I know came up at a number of the public meetings. How, if you know, would the city track when these costs have been recovered so that a landlord would not be doing that surcharge in perpetuity? Is there a computer program that may be in place that would, in 10 years, because I think most of us might not be up here in 10 years.
We have a proprietary software system that manages our rent stabilization information, and we would, if we're going in this direction, we would explore some form of an option. Right now, we're doing a major upgrade of that system where we're converting it to an 100% online model, and I think that it's appropriate that we could look at capturing that within the system itself while we're doing this upgrade.
Microphone.
Am I understanding that we do not want to make a motion, or we want to make a motion to move the process?
I think we want to put this to the community for response, something more concrete. Is that what you were going for, Commissioner Gregoire?
Yes.
Yeah.
So we're not making a recommendation tonight, but we're just moving staff's assessment on for further discussion, not at the community meetings, and also amongst the commission and staff at future meetings.
How would that look, Mr. Noonan? Would that look like the Rent Stabilization Commission is considering this recommendation to City Council? You could put that to the community. How would this look tonight for us?
I used the term draft proposal.
Okay.
And so I would, if you're comfortable with that, I would stick with that description, that it's a proposal that the commission has put out to the community, seeking input and feedback from community members on that.
I'm still not comfortable with that. I have no problem with acknowledging at future meetings that this is what staff has proposed to our commission thus far. But I'm not ready to make any kind of a draft proposal recommendation at the public level. I just think it's premature until we've had our final public meeting this Saturday. And I think we need a little bit more time to ruminate. We've had some really excellent points brought up that I don't think that we have fully fleshed out. So I'm not comfortable yet. I understand that we'd like that for the final meetings, but I would ask that perhaps we hold off on that until the June 28th meeting.
I'm curious the other commissioners' votes. I'll give my preliminary vote would be, I'm fine with the draft proposal. I want to see what the community has to say about it. I'm curious what my fellow commissioners think, if we're going to vote on this.
It might be helpful to do that if you have a split commission and it appears that you may have a split commission. By taking a vote on moving the proposal forward for discussion.
I personally would like it.
We've closed public comment, haven't we? This would be a repeat speaker.
Well, yes.
We don't typically reopen public comment.
Thank you. So, Victor, I know you resubmitted, but public comment is closed.
Yeah, they're closed then.
Got it.
There's a second public comment period.
My apologies. No, I'm sorry.
Yeah, so back
No, really,
to
I'm sorry.
my initial question to the two silent commissioners. What do you think?
Well, look, I support I support moving the draft proposal forward to the community meetings for further discussion.
If you make a motion, I'll second.
I hereby move that the commission recommend that the draft proposal be disseminated to the community and discussed at upcoming community meetings, and that any feedback of the community be summarized and presented to the commission at a future meeting.
And I second that.
And could you tighten that up a little bit? I'm sorry. Shorten that up a little bit for me one more time.
I'm not sure I know what I just said. So I think I was saying, I move that we recommend that the draft proposal be disseminated to the community for further discussion and exploration at upcoming community meetings, and that any feedback from the community be summarized and presented to the commission at a future meeting. I think that's what I said.
And you seconded?
Yes, I
Commissioner?
second.
Okay. Yeah, I agree with you with that. I have nothing against it, and definitely more input from the community will be beneficial, will be helpful to hear more ideas, more thoughts on it. So when I was firm about my position is in regards to whether NOI or a cost sharing pass-through. So that's what I meant when I said I'm ready to support the staff's proposal. So, but yeah, I agree that we should hear more from the community. And
Just to clarify, we're not recommending this
No,
draft. We're just
no.
saying that it can be brought forward. We are acknowledging this in essence and saying bring this forward at the public level. But the commission is not making a specific recommendation pertaining to this.
And my thoughts
I'm okay
are,
with that.
yeah, I just want to show our hand here so people can have an input.
Any further questions or comments? Can we have a roll call vote?
You may. Commissioner Maggio,
Aye.
Commissioner Gregoire,
Aye.
Commissioner Topchian,
aye.
Commissioner Charity.
Aye.
Vice Chair Bergstein.
Aye. So then we will
So be it.
do it. I'm still a little
You know, the one
concerned.
thing I would add is at these upcoming community meetings, it would be great to get the public's input on the hardship waiver or hardship exemption. Because it would be great if City Council eventually had some guidance on what sort of hardship waivers or exemptions would be
Right.
workable for our
Because
the
it's
members
not
of our
only
community.
maybe economic hardship, but it's also fixed income or people on disability. Right. There's a few other things I can think of here.
I'm talking out there in TV land. I would hope that perhaps more property owners or management companies would become part of the process. I know in our packet is a letter from Apartment Owners Association, but I like seeing physical landlords present. So Saturday, 11 a.m. in these chambers. Am I correct? Nope.
It's at the auditorium, so that's the old city council chambers, the
Next
gym.
door.
Next door,
Okay.
yes.
11 a.m. this Saturday.
11 a.m. this Saturday.
Okay. And with that, if someone would like to call in Chair Kirby's, if he's still here. Did he decamp? His phone's here, so he's got to be here somewhere. I'm going to take just a 1-minute recess so we can round up our wayward commissioners. There they come.
Here they come.
Oh, there's one. Yes, you can. Is Kirby's out there? Do you see him? All right.
There he is. Welcome back.
Thank you.
We're at, there is no other items. We're at public comment. There's one speaker. Victor.
All right. Welcome back. Okay, so we will.
Public comment.
Public comments.
Commission and staff.
We do have one public comment. Victor Olmacheco. Are you still? Yeah. Saw you come in. You'll have 3 minutes.
Thank you, Chair Kirby's. Victor Omolchenko, longtime West Hollywood resident. I'm happy that we are having an additional meeting this coming Saturday, July 16th at 11 a.m. in our old, where the City Council used to meet, in the WeHo Auditorium. So for those folks who remember all the City Council meetings there, you'll want to maybe go to one of these meetings because it might be one of the last meetings in that historic auditorium that we had for the longest time as our City Council place. I attended quite a few of the previous meetings coming up to what I had said earlier today and this evening. And what I just wanted to reiterate is that there are still, and I had mentioned this before, there are still perhaps some buildings that need to be added to the list because the 832 buildings that were identified by the engineering consulting firm, they did not apparently include any of the soft story structure buildings which could not be seen from the street or the side driveway. So there are buildings in my neighborhood on Laurel Avenue that actually have those soft story structures, tuck-in parking in the back of the building, which can't be seen from the front of the building. So we may have even more seismically compromised soft story residential rent-stabilized apartment buildings left in the city that need to be looked at in any way that the consultant and the city can come up with, maybe those Google satellite maps that you can get on the internet and you can kind of zoom into a backyard instead of just the front street. So I just bring that up because if we are going to go forward with with this effort, we want to be sure that all buildings that require this kind of seismic upgrade are actually on the list. So thank you for I saw many of you at most of the meetings that I had attended. I think this has been a good process, and I'm happy that the community can still weigh in on the staff's assessment, which you've said you could now forward to the community as a draft proposal to look at the details about the hardship waiver and the sharing of the costs. And I think this is all in the end very, very important for all of us and for our public safety. So thank you for working on behalf of our city, and I welcome new Commissioner Karen O'Keefe, and I don't think I've been to a meeting since Mr. Charity came on board. So thank you for your service and the service of all of you on our very important Rent Stabilization Commission.
Thank you, Victor. There are no other public comments, so we will move to commission comments. I just wanted, there are no comments? Was that?
I do.
Oh, you do?
Yeah.
Would you like to go ahead?
You go ahead.
Okay. I just wanted to bring up, kind of give you an update on 3 different bills that were in front of the State Assembly this last, about 2 weeks ago. They had their final deadline for bills that were introduced in one house, had to pass that house to get over to the bills in the Assembly had to get over to the Senate if they wanted to proceed. And so there were a lot of bills, about 115 bills that were considered on the final day. I think it was May 29th. And 3 bills specifically had to deal with tenants. And I wanted to kind of highlight, there's a gentleman, Dean Preston, who's the executive director of the organization called Tenants Together. It's California's statewide organization for renters' rights. He did a little summary of the evening. I'm not going to read it verbatim, and I'm not going to add his comments into it, but I did want to update people on what happened to a couple of the bills that I find alarming. Assemblymember Rob Bonta introduced AB 2925. This bill would have required a landlord to have a reason, any reason, to evict a tenant and to state the reason in the eviction notice. We, here in West Hollywood, have that protection already. And unfortunately, when it was voted on by the Assembly members, only 16 of the 78 legislators voted for it. The same story for Assemblymember Richard Bloom, who does happen to be my boss. Richard Bloom's modest tweaks to the Ellis Act in AB 2364, a bill that was supported by the City of West Hollywood. In fact, Allison Regan, staff attorney for the City of West Hollywood, was very instrumental in helping us draft the language. This bill died with only 27 votes. 51 refused to support it. In another bipartisan nod to the real estate industry, I'm sorry, that was his commentary. That bill would have done nothing to people who are using the Ellis Act law correctly. It only affected people who were for violating the Ellis Act. And still, it only received 27 votes. AB 2343 by David Chu, this bill would have expanded tenants' time to cure eviction notices, was headed to the same fate for defeat, but Assemblymember Chu gutted his own bill to appease the industry and secure passage. Basically, he was trying to move it from a 3-day notice to a 5-day notice so that tenants have time to actually respond. Many times, tenants don't know their rights. He ended up having to change that from a 3-day notice to a 3 court day notice, so that at least they get 3 business days to respond. That bill was defeated. Basically, the point that Dean is trying to make in this is that what has changed in Sacramento for the good is that Assembly members have been bringing controversial bills to the floor and to be voted on, where in the past they have not. And so now we're starting to see which Assembly members or which senators actually support making these reasonable changes in law, and they should be held accountable. So I just wanted to bring that to your attention. You can go online, read Tenants Together to see more information about the bills, but it's very alarming what many people who we thought were supporters of tenants' rights had a change of heart when they actually had to vote on bills, and I hope that everyone will take a look at those positions. And that's my comments.
The comments.
Yeah, what's that called when you're on a
Chair
soapbox?
Cook-
Thank you. That's
Chair-
what I was looking for.
Chair
I was going to say
Cook is-
milk cart.
We just just share the names with us, so we're not going to vote for those people ever again.
Rob would call it speechify.
Seeing no other comments,
No.
then we'll have to.
No, excuse me.
Oh, I'm sorry.
Yes,
you
that's
do have
okay.
one.
You
I'm
did.
sorry. You let me go first.
I prepared notes. I wanted to start a conversation. This might be something that needs to be agendized or for a study session, but pertaining to commissioners bringing issues before our commission and also members of the public pertaining to non-rent stabilized apartments. Our ordinance only pertains to buildings built before 1978 and does not cover inclusionary or HUD buildings. So if a commissioner hears from a tenant about an issue in a building not covered by our ordinance, really by bringing it to this commission or bringing it to rent stabilization staff, all it's doing is adding another layer. And that layer needs to be peeled away and then it goes to the proper department. The last two instances that were brought up by commissioners were both code compliance issues, so it would have helped resolve the issue much more quickly if we had gone straight to code compliance. I don't want to give the public the false impression that this commission and rent stabilization are able to assist non-rent stabilized buildings, non-rent stabilized units, or even stabilized units on issues such as public safety, whether a building could be torn down, and we hear a lot of that around election time. So I wanted to urge my fellow commissioners as well as the public that if there is an issue you hear about from a tenant in a non-rent stabilized building, rather than bringing it before this commission, that you direct that tenant to which department can best assist them with that issue. Certainly if the issue is not resolved, particularly for those commissioners that are direct appointees, you can talk to your council member about an issue you feel is not being resolved. Josh and I have the luxury, we can talk to all 5 of the council members since we are at-larges. So that's it. I just want to clarify that this commission can only deal with units that are covered by the rent stabilization ordinance. We have absolutely no authority, no sway over buildings built after a certain date or inclusionary units or HUD. So I want to encourage the commission and the public to go to the appropriate department at City Hall rather than bringing it here. End of my comments. Thank you.
Any other commission comments? All right, I haven't forgotten about you. And now we'll move to staff comments.
Hi, my comments are brief. I just wanted the commission to know that I will not be here for your next meeting on June 28th. I will be on vacation, so I will see you again on July 12th.
Who's covering? Gloria?
Gloria Vilas will be covering for me in my absence.
Excellent. Thank you. All right, with that, I believe that I would entertain a motion to adjourn.
So moved.
All right. We're adjourning till the meeting, we'll adjourn till the next meeting of the Rent Stabilization Commission, which will be June 28th.